This Honorable Court of Appeals of Tennessee is now in session.
Good afternoon. Before we call the case, a couple of things. I want to thank the lawyers for participating in this oral argument by Zoom so that we can continue the work of the court, which is the work of the people of the state of Tennessee. If we have any technological problems, we don't anticipate any, but if we do, we'll just take a pause and work through them and get back ongoing. Call the case, Mr. Hibner.
Kelly L. Phelps versus State of Tennessee.
We'll hear from the appellate.
Your Honor, my name is Jason Lee. I represent plaintiff Kelly Phelps, and I've reserved 2 minutes for rebuttal.
That'll be fine.
This case is a Tennessee Human Rights Act sexual harassment case against the state of Tennessee for significant sexual harassment, a sexually hostile work environment, and retaliation against my client. The bottom line on this appeal is that the trial court improperly granted summary judgment on a very narrow issue and ignored evidence and law contrary to the court's ruling. In fact, the court didn't even address a lot of those things in its opinion. First, some of the facts. Kelly Phelps was grotesquely sexually harassed on Tennessee state property at the Paris Landing State Park after a Tennessee-sponsored and staffed Halloween party in October of 2017. Josh Walsh was the assistant park manager for Tennessee. He was also a ranger and an officer of the law. He was second in command at the park, and he openly sexually harassed multiple women, including touching, groping, and numerous sexual harassing comments during the Halloween party. The facts show that he also had previously sexually harassed women the prior year at Tennessee at another event where alcohol was served in almost the very similar manner. Management at Tennessee knew about this. At this party, a party in question, he was served 15 alcoholic drinks, at least, because they didn't account for the free drinks that were handed out. And the state of Tennessee did this despite knowing about his prior issue of sexual harassment approximately a year prior, and they still served him this alcohol. At the party, he sexually harassed a manager in addition to multiple other women. And this was open and obvious, and the testimony is overwhelming from witnesses about this. Then, after the Halloween party that was state-sponsored, several of the people who worked there at the state, as well as Mr. Walsh and Ms. Phelps, moved to another area of the state of Tennessee property for, we'll call it an after party. At that time,
let me ask you this, Mr. Lee, because I wasn't 100% clear from the briefs, but this after party was at someone's residence, correct? But
it was outside. It was outside the residence. So it was actually on state property. It was not inside the residence.
Okay. And is the residence part of state property itself?
It is, but it is state property. It's all on the Paris Landing State Park. Mr. Littles doesn't own the home, but that's the way it's structured. But it was actually on the property, and he was an officer of the law, of course, so he had complete authority on state property. So at that point, the sexual assault, which has been described, she was put into a headlock. He rubbed his semi-erect penis up against her, dry humped her on multiple occasions, 2 occasions. The trial court found properly on 3 major issues. First, that Josh Walsh was the supervisor, at least that there is a genuine issue of fact, that he was the supervisor under the THRA. Second, that Tennessee knew about Walsh's prior sexual harassment and failed to take prompt and appropriate action. And number 3, that the sexual harassing actions of Walsh were sufficient to impose liability on the defendant. All those findings were correct. But the issue we have with the trial court is what they ultimately held, which the court found that they didn't consider it actionable sexual harassment because it basically didn't take place within the traditional workplace. There's 2 major issues with that. First, the case law and weight of authority clearly shows that legal ruling is wrong. The court basically had a bright line rule. Well, it occurred outside of the workplace, therefore no actionable sexual harassment under the THRA. But what the court did was they relied upon the Span Tennessee Court of Appeals decision, which didn't address that issue at all. In dicta, throwaway language, the Span court said that the THRA prohibits sexual harassment, quote, in the workplace. That's all it said, but it wasn't addressing that issue. It was basically boilerplate like we have at the top of every opinion, just discussing the general what the law is. Well, The term in the workplace isn't really addressed in Tennessee courts very much. So of course, in cases like this, we look at Title VII, we look at federal law. Well, we cited numerous cases where sexual harassment outside of the workplace is considered and found to be part of the sexually harassing conduct. And the United States Supreme Court in Burlington, which is obviously one of the most important cases, they said the substantive provision of Title VII seeks to prevent injury to individuals based on who they are, i.e. their status. And federal courts have long interpreted Title VII to include sexual acts outside of the workplace as long as they have a connection to the workplace, which our situation clearly did that evening. The Seventh Circuit found that the sexual act need not be committed in the workplace to have consequences there. But at the least, the harassment must, as in Meritor, be an episode in a relationship that began and grew in the workplace. The entire relationship between my client and Josh Wallace was based in the workplace. He was a supervisor in the chain above her. All of his actions towards her grew out of the workplace. The First Circuit also found that actionable conduct that in a non-workplace event. The Second Circuit in the Ferris versus Delta case also found that there was one event of sexually hostile, I believe it was a rape, but it was outside of the traditional workplace, and that was found to be actionable under Title VII. Even in Tennessee, the Eastern District of Tennessee, and this citing a Sixth Circuit case in the Vanover decision, found that, quote, when an employee is forced to work for or in close proximity to someone who is harassing her outside of the workplace, the employee may reasonably perceive the work environment to be hostile. The trial court did no analysis of any of these cases, didn't even cite this rule, just cited Spann with the general statement, outside of the workplace, game over for my client. And that was just a wrong decision. The actions of the supervisor, you got to think about this. A boss or supervisor is still a person's boss or supervisor, even if they're outside the workplace. And in this particular situation, the state of Tennessee is trying to talk out of both sides of their mouth, because that evening they punished two employees, Jeff Utley and Allison Otello, were written up and provided reprimands for conduct only at the after party. Michael Robertson, director of the state of Tennessee Parks, issued a reprimand, and counsel says, well, it's just a written reprimand. It's not a formal write-up. They took action. They cited the Tennessee Human Resources rules. And that in that citation, which is part of the record, it says, Allison Otello, quote, attended an after-party event where she admittedly removed her shirt, exposing her bra and the remaining areas of your upper body to other employees attending the after-party. That was in their official record. The state of Tennessee exerted control over what happened because it's state property. And now, of course, they want to say, oh, no, we have no responsibility for what happened on property to Miss Phelps. So the state of Tennessee is trying to have it both ways, and that evidence alone shows the level of control that they've asserted. The second major issue with the court's decision.
Counsel, excuse me, let me ask you a question before you go. I mean, is there any limit to how far, and I'm trying to figure out how to say this, is there any kind of a limit to how far removed from the workplace it can be under your argument? I mean, what if this had been, without question, a private residence 10 miles from the house, from the park, and it had happened? Would your argument still be the same?
No, it would not. It would not. I think there has to be a nexus to the employment, and there was here. And the reason is this: it's an evening of activities. State-sponsored party, serving him alcohol. He's openly sexually harassing multiple women. One of the managers even said, I should have done more. I should have stopped it. Nothing was done. It's on the same property, about a block to a block and a half away, and it happened less than an hour afterwards. He was the top person, the assistant partner, who was the top person on site at the park that night. He was the top individual, and he is an officer of the law.
I understand, but my question now is, so if this had been at a purely private residence, everything else is the same. All the other facts stay the same. The after party, though, is located at without question, a private residence. Would your position be the same as it is now?
Yes, it would be, with all these other facts, because the state of Tennessee served him alcohol, and that's where the Tomka decision comes into play. The Tomka decision is a Second Circuit case where a woman went on a business trip, and she was with other employees, and the male supervisor purchased on company credit card alcohol for everybody. They all drank alcohol. Later that evening at the hotel, unassociated with the business dinner, which she wasn't paid for, she just felt pressure to go to, she was raped. And the court found that because the employer, through apparent authority, provided this alcohol, that tied it to the employment. Further, he was her supervisor, and they were acting in that way at a party. So it's the exact same thing. It's an after party, so to speak, although I wouldn't call what happened in the hotel room an after party, obviously, but it's a continuation of events that evening. All of these events are tied together that evening. And so that is the difference here. That is the distinction, but it also certainly helps that it's also on state of Tennessee property. And they exerted control by writing up Jeff Utley and Allison Natello for their conduct at that after party. And now they want to say, well, we have no responsibility for any of that. The Rangers are responsible for the security and upkeep of this whole Paris Landing State Park. And that's who they are. And so it's not some tenuous situation off, at some location, not on property. So the Tomka decision is another important decision that shows, number one, that the provision of the alcohol is a tie to the evening. The sexual harassment that evening that occurred to multiple women, this wasn't just my client, it was 5 total women, was done openly and obviously in front of management. And so this whole evening continued and ultimately culminated in what happened to my client. The court didn't discuss any of these things. It didn't. And there's numerous other cases, which I'm not going to go into, which we cited, which address, it does not have to be within this technical 8 to 5, on the premises workplace, as long as there is a tie to the employment. And that brings me to my second big issue, is that the Campbell, Tennessee Supreme Court decision discussed that conduct underlying a hostile environment claim does not need to be clearly sexual in nature. They rejected a narrow definition of that. And they determined that intimidation and hostility towards women, because they're women, can obviously result from conduct other than sexual advances. And that's what happens after this event. My client reports it. And then Josh Walsh starts stalking her, starts staring at her, leering at her for hours. He would wait for her after work. He would follow her home, all in company, Tennessee vehicle, Tennessee uniform, Tennessee firearm. All of that is going on. And so that course of events is a continuation of the hostile claim. That is a continuation of the sexual harassment claim. And it was directed at her because of her sex. He didn't do it for any other reason. And there's a case that we cited which specifically found that stalking and leering and staring is a male aggressive tactic towards women, which is sexual in nature, that men don't do to men in the same way. And that is based on their sex. And that's a very important thing. Counsel argued that, well, that's all just retaliation.
Counsel,
yes.
This was done after she made the report.
Correct. That's right. So, and that went on for months. She reported it to management. The investigator knew about it, and they never took it to the workplace committee. They never did anything about it for 2.5 to 3 months. So there's other issues here, which I've addressed in my brief, and I may address on rebuttal, but I see my time's up.
Yeah, time for rebuttal. We'll hear from the appellate.
May it please the court, I'm David Rudolph of the Tennessee Attorney General's Office. I represent the defendant state of Tennessee in this case. The trial court properly granted summary judgment to the state on all claims of plaintiff Kelly Phelps. First, trial court properly granted summary judgment to the state on plaintiff's sexual harassment claim. Plaintiff alleged one act of sexual harassment. That one act did not take place at the park-sponsored Halloween party. Instead, it took place after the Halloween party, at the after party, around 2:30 a.m. in the morning at the private residence of another park employee. This after party was
Counsel, did the state cite other parties, participants in that party because of their conduct or their dress?
Well, I think you can see in the record, Your Honor, we've carefully delineated between what happened at the Halloween party and what happened at this after party, because there was one was in the workplace, we consider the other one as not being in the workplace. That doesn't mean that the state can't discipline somebody, but there's a different way you look at it, because clearly we have control what happened at the Halloween party in the workplace. We don't have control over what happens at the private residence. Even though it's on our premises, it's being rented by an employee. It is his private residence. So
Mr. Rudolph, I'm sorry to interrupt. If you don't have control over what happens at the after party, then how do you write up employees for conduct that occurred at the after party?
You can write up employees for things that happen outside the workplace. Where an employee engages in conduct that's unbecoming of a state employee. It's a different analysis. And as you can look at the record in this case, the Workplace Harassment Committee struggled with that. What they did in that case is they put a little bit of a higher standard on what was happening at that private residence, and issued a verbal counseling to the one employee who was running around without her shirt on and with a bra on, basically saying you're engaging in conduct that's unbecoming of a state employee, but we're not going to give you a binding written warning. The difference with the plaintiff, we gave her a binding written warning because she was wearing a sexually explicit bib. Because it was at the Halloween party, we gave her a written warning a little higher. So that the committee looked at where did the events take place and adjusted whatever discipline that based on where it took place.
Let me ask you this, Mr. Rudolph. It does appear that the trial court took the sentence from the Span case, which is just kind of a sentence that explains in really general terms, what sexual harassment is. It did not attempt to define where sexual harassment has to take place. That was not an issue. That issue wasn't developed in the Span case. Are you aware of any cases that specifically say the sexual harassment must take place at the workplace? And if so, I'm just trying to think of what are the limits to that. So let's say if you go to work with a colleague and or go to lunch with a colleague and they sexually harass you while you are at lunch, is that not actionable because it didn't take place, quote, in the office?
I think that would be actionable, Your Honor. You're still within the work hours. It's clearly you're still within the work events. I think.
What if it was an after hours dinner?
I think those would probably not be. If it's outside the work hours, it would not be a workplace harassment event.
I'm just thinking about, for example, people in sales. A lot of times people in sales, they entertain folks and they do dinners for folks. And let's say you have a dinner like that and something like this takes place at a dinner. You're not at the workplace. So, is that the bright line test? Are you at the office, at the physical workplace?
And that's real. There is a bright line test here. I think if you're outside, if you're at after hours at just a social event, that's outside the workplace. Now, the argument that Mr. Lee was trying to make is, well, if that has consequences in the workplace, then the court can look at it as a hostile work environment. Here, we put in the record the interrogatory answers of the plaintiff. She only cites one event. She doesn't say she had a hostile work environment in the workplace. It's very important to look at the interrogatory answer we put in the record. We asked them separately, identify each act of sexual harassment and each act of retaliation. And she didn't say that Mr. Voss did anything to her in the workplace. So those cases are different.
I thought she said that after she reported the incident that he leered at her, stared at her, waited for her outside, sort of stalked her, I guess.
Right, yeah, and that's if you look at it's in R volume 6, pages 798 to 805. The interrogatory answers, this acts of leering and staring, under oath, the plaintiff said those were acts of retaliation that happened after she complained about sexual harassment. So the court has to separate. She can try to claim that she had a retaliation hostile work environment, but that is, she cannot say that that's a sexual harassment. He's trying to kind of mix them all together and say, oh, this is one big sexual harassment hostile work environment. We cited the cases. You can't aggregate different acts that were taken for different motives. If it's a retaliation, you got to consider it under retaliatory harassment. The cases we cited, the Morris case from the Sixth Circuit and the Mass case from the Sixth Circuit.
I'm just thinking as a plaintiff, how one does that. Like, how does one say, well, I think he may be leering at me in retaliation, as opposed to he may be leering at me because he is sexually harassing me?
Well,
That's
well, here, Your Honor, what she did, she reported this incident a month after, in late November. And when she reported it, she only reported the incident at the after party. She didn't say in that month, he's been leering at me and staring at me. It's clear, both in the interrogatories and the affidavit that Mr. Lee filed in support of against the summary judgment motion, that these are acts of retaliation that he's alleging.
Well, wait a minute, counsel, excuse me, but you just said she didn't report, when she filed her complaint, she didn't report these leering, the staring, the driving by in the state vehicle, wearing his state ranger's uniform, carrying his firearm, because that happened after she filed the report, correct?
Correct.
So she couldn't have alleged those acts in her report then, could she?
She could not, Your Honor. And so we asked her in an interrogatory answer, so identify each act of sexual harassment and identify each act of retaliation.
And so it's your position, excuse me. So it's your position that since she identifies it as a act of retaliation, it can't be sexual harassment as well?
That's correct. She's bound by those answers. That's a different motive. If you're taking acts because somebody reported you for made a sexual harassment complaint, that's retaliation. And the Sixth Circuit cases that we've cited, the Morris case and the Mass case, make that distinction. You can't have it both ways. She clearly states that these are acts of retaliation, and that's the basis on which we moved for summary judgment. We put that in the record. Those are acts of alleged retaliation. He can try to argue that that's retaliation.
I'm sorry, didn't the judge also dismiss the retaliation claim, or did he not?
He did. He did. He basically said that she had not established a materially adverse action.
So without the assuming then that you cannot sexually harass if you're away from the workplace as they were at this time, then without that, you can't have the retaliation, the adverse actions.
You saying that you can't have it, Your Honor?
Yeah.
He can they can still assert that claim, but they have to argue it under that it's retaliation, hostile work environment. And I don't believe that they've established simply that he's staring at her. The acts that they've alleged, we don't think that's sufficient, severe, or pervasive retaliatory harassment. It's a different analysis.
Well, then the trial court sustained the same actions within the other case?
But in the other case, the other plaintiff was sexually harassed at the Halloween party, was sexually harassed in the workplace prior to the Halloween party, and the court said there was an issue of fact. So there clearly was a difference. Ms. Phelps only said she was sexually harassed at the after party. So that was why he addressed that as, it's a private residence. even though it's on park premises, it's still a private residence. So that's, and then he focused on the retaliation claim.
Well, counsel, was the after party outside the house?
It was inside, the inside and outside the house. Absolutely.
Or what does the proof show? What does the proof show as to what control the state still has over the property?
The state would have control over the property, but this was at this person's house.
I
So
understand.
I think it's primarily would be a private residence. We would have control over things that are outside.
Yes. So the state would have control over it, and who would be the law enforcement official that would handle that for the state on the state property?
I guess overall, people that are perhaps security.
It'd be the rangers, wouldn't it? It'd be the park rangers, wouldn't it? Is that a yes?
Well, you know, at 2:30 a.m. in the morning, it may be perhaps a night security type. So I mean, that's the problem we're having. It's 2:30 a.m. in the morning, and they're having these they're going over to his house.
Was there any proof showed that the park rangers, once they were off duty, even though they were on park property, that they had nothing to do with enforcement on the park property?
I think whoever would be on there were people on duty, but you know,
even if the park ranger wasn't on duty and he's on the park property, was there any proof showing whether or not he would have any responsibility towards enforcing the law on park property?
Which are you talking about? The park ranger?
Just a park, yes, a park ranger located who's stationed at that park, and he's off duty. He's driving away, but he's still on park property, and he sees a violation. Is he still responsible for taking some action, or does he just say, "Well,
I think he would be, Your Honor, but the distinction is this: that's not the record. That's not what they didn't. There was nobody that witnessed something that they should have gone. This is
no, it was the park ranger that did it. Is that right?
That's true, Your Honor. But he's off duty. The person that was on duty, the night ranger did not see this take place. So you kind of.
So he was off duty on park property leased to a private individual.
Correct.
Okay. I'm sorry, go ahead.
Well, it is important, as Your Honor can see, that the difference between the workplace and the sexual harassment claim and the retaliation claim, and separating the two, and not, I think it's important. And the lower court tried to do that. He differentiated the two plaintiffs in this case, one of which was clearly at the Halloween party in the workplace. Ms. Phelps, it was not. Most of her allegations are really what happened after she complained about it. And we think the court properly granted summary judgment on that retaliation claim as well. I can see my time is up.
Well, I'll tell you what, we asked you an awful lot of questions. If you want to say, we'll give you a little bit more time to address the retaliation claim.
I do think it's important for the court to differentiate between what are the acts of sexual harassment that she claims in her sworn testimony or interrogatory, and what are the acts of retaliation, because there's a different way you have to review those. We're dealing with one act of sexual harassment at the after party. That's under that claim. And we're dealing with a number of acts, as you will see in the interrogatory answer, that on what they say is retaliation. You know, just a couple of pages of retaliation, that he leered at me, that he stalked me, he did this. they clearly made it clear that that was retaliation as opposed to sexual harassment. And the court's got to make the distinction in those cases. They shouldn't be allowed to combine the two and try to improve their claim. But we're dealing with, as I say, an incident way after work hours, and then these other events that really don't relate to that. So I think the court properly granted summary judgment on both the claims.
All right, thank you, counsel. We'll hear from the appellate rebuttal.
Your Honor, I noticed that there is no case that addresses the outside work hours concept. The case law on the tie is about whether there's some tie to the employment relationship, and that's clearly met here. And that's the big issue. Counsel spent a lot of time on retaliation versus this and that, and there is a distinction there, and I can make that distinction. When he is staring her down and leering at her and intimidating her in that way, his actions are still a continuation of harassment due to her sex. And that's what Campbell talks about. Campbell was talking about cold shoulder treatment. She would come, this is after the report, she would come into the lunchroom, everybody would leave. He says your interrogatory answers didn't list those acts under the sexual harassment. It listed, when they asked you, it said list every incident of sexual harassment. Listed only in the interrogatory answers, listed only the after hours incident, and under the list all the retaliatory actions, all those other actions were listed under that. Right. The way I approached it was there was the word sexual harassment is different. The stalking and the staring and the leering is hostile environment due to sex. That's the way Campbell refers to it. He didn't refer to it. That interrogatory doesn't ask for that. So we listed everything in the interrogatory responses, and she testified in her deposition to everything as a combined. I mean, my client obviously doesn't know the legal distinctions, but it's all in there. But he didn't. The first one he asked for sexual harassment, not hostile actions based on sex, which is different. But Campbell brings that within sexual harassment claims. So it's just poorly worded interrogatories. And so you look at the entire picture, and once again, all that is moot because the original event is sexual harassment under the THRA. And I didn't even get a chance to address the retaliation claim, but the court ignored two other retaliations. It wasn't just about the bib. It was also about her reduced work hours and less desirable work shift as a server, which we submitted an affidavit on. It was also about the state's failure to react, and management failed to address his continued harassment. So all those things combined, the court only talked about the bib and the write-up for the bib, which was an error. So, but that's all I have, Your Honors. Thank you.
All right. Thanks to counsel for both sides. We appreciate your briefs and your argument on this. Mr. Hibner, if you would, please recess court till our next scheduled case this afternoon.
This honorable court is now in recess until 2 p.m.
Thank you.
Thank you.
Thank you, Your Honor.